relation to lands at Strongcastle, at St Johnstone's of the Rye, and lands at Knocknalling Estate, St Johnstone's of the Rye, both at Castle Douglas. My name is Paul Coquette, and I'm a reporter with DPA. I'm jointly appointed with Katrina Reid, who's on the call this morning to report to Scottish ministers in respect of these two applications. Katrina is appointed in relation to a wider and separate application under Section 37 of the Electricity Act 1989, and she is appointed alone in relation to those matters. I'm not appointed, but we're jointly appointed in relation to way-leave matters, and I'm the lead reporter in relation to the way-leaves, and intending therefore to chair the meeting today, although Katrina may well chip in with questions or observations as discussion goes on this morning. The parties present this morning, and I'll just ask you to introduce yourself in turn, are Shepard Wedderburn for SPT and David Robertson, I think led by Sarah Bennett, on behalf of the objectors. So I'll first start with Shepard Wedderburn to introduce parties for this meeting.
Thank you, sir. I'm Murray Thompson. I'm a partner in Shepard and Wedderburn, instructed by SP Transmission, and joining me today is my colleague Magdalena McLean, who's been involved in the overall examination process into the Section 37s, and also Mark Peebles, who's instructing me from SP Energy Networks Legal.
Thank you. And Sarah?
Good morning, everyone. Sarah Bennett. I work down in Castle Douglas for Davison and Robertson. I'm an associate. Ian Austin's a director, so really technically he's leading rather than me. But that's the two of us. We're both acting for the Ramsays in connection with the KTR project.
Okay, excellent. That's fine. Thank you. Thank you for that. Just by way of a couple of preliminary matters, just as you know, this is a recorded pre-examination meeting. It'll be available for access at a later date on the DPA website if you need to consult with it, and you can search on the website and searching under the case reference numbers, which for these two cases are WAY-170-17 and WAY-170-18. As always with pre-examination meetings of this nature, which are being recorded, participation in this is being taken as consent and agreement for data protection and GDPR purposes, and so we'll proceed on that basis for this morning's meeting. By way of a general summary, which I think many of you do know already, but just for the record, these way-leaves are amongst a number of way-leaves applications that have been made by SPT and originally SPD. In relation to sites at the Kendoon and Tongland site, which was the subject of the Section 37 application. Katrina primarily held a number of hearings and inquiry sessions in, I think, October, but certainly also November last year. I think they really started in October for the Section 37, which the process is now completed in terms of evidence gathering, and there were actually three hearings were set for way-leave matters, but only one proceeded at the end of November. The reason I mention this is partly by way of scene setting in terms of where me and Katrina are for our evidence gathering and consideration of the issues before us and report writing, but also just to emphasise that we are now moving to the stage. We're not quite at the completion, perhaps, of all the evidence gathering, but we're now moving towards the stage in those other matters of closing submissions and finalisation of what we're doing. So part of the reason for asking for attendance this morning was just to get a kind of an indication in relation to one or two, and there is actually one other matter, not in relation to parties represented today, where we need to do go through a similar process, but just get a sense of when we can take it that matters are resolved as they are resolved, or if they're not resolved, require to be considered by us and make a decision as to what we say to ministers by way of our report, and in particular reach a view as to when we can be confident that we've now got all the submissions and seen everything that we need to see before we can write up our report. And so this discussion, and I'll go into the agenda that we've circulated again in a moment, but this discussion is really designed in order to allow us to be clear as to the task ahead of us and the extent to which matters remain unresolved, in order that we can ensure that this collective and somewhat complex process, obviously multi-party process, can be progressed in a way that's as expeditious as possible, and make progress now, as I say, since other matters have now gone to hearings, and I think both of the objectives in this case are the objectives in this case for both sides rather, what they have in common is they've not asked for a hearing, and that was the reason why they weren't involved in the hearing sessions that we arranged for the way leaves at the end of November. But that nevertheless still leaves a situation where there are some matters to be resolved for us before we can start looking at our reports. The relevant documents that I have, I think, aside from the applicant's initial the supporting documents that I have, I think, are relevant for today's meeting, are first of all Sarah's email of 16th May of last year, which set out various grounds of objection and a statement of case as they then stood. And the email yesterday with an update as to the position regarding subsequent discussions. And the third document, I guess, of relevance is obviously the agenda that was issued on the 19th of December. The agenda items, I suspect, are common to both, and we will be able to deal with those collectively. But I'm intending to proceed on the basis of the agenda as was circulated on the 19th of December. So that's where I am, and Katrina is, in terms of preliminary matters. I don't know if anybody has any comments or observations on that or any other issues they want to raise before we move on to consideration of the outstanding issues per the agenda, and start with the applicants.
No, I think that's a very comprehensive summary. Nothing further to add, sir.
Okay, thank you. And Sarah?
Ian potentially maybe has something to add.
Perhaps can I just
yes, of course.
lead on this one, sir, if that's okay.
Yes, of course.
So I think just context, we've been instructed to come along today really to try and just give you a proper update, and in the spirit of we're trying to work together to get a voluntary agreement, and that is very much what our instruction is to try and resolve this voluntarily and get a voluntary agreement. And today is really to just give you that update and hopefully show that there's been quite a lot of progress.
Well, that's very helpful, because that's what I was next going to say. I was going to say the first issue to ask either Ian or to Sarah, just to give us an update. Obviously, I've seen the email from yesterday, but it'd be useful perhaps if you could summarise the kind of progress you made. I gather you're having some discussions with Malcolm Thompson since the turn of the year, but maybe if you could just do exactly that and give us an update, and then we can then think of what that means for next steps to try to assist all of us to come to a resolution, or if a resolution can't be found, then get an idea of what me and Katrina need to do next. So over to you, Ian.
If I can start by just about a little bit of context,
Sure.
The area in question where the line is going to come through is in by land for both of the two holdings, and it's therefore it's the most productive land on the holding, and it's very, very central to the operation of those holdings. So that's why it is very important, very sensitive, even though in terms of proportion of area to the whole farm, it could be viewed as quite small. But that's the context of this.
Yeah, that's very helpful, actually, because that was one of my questions I was thinking about, having looked at the plans again in preparation for today. So that's a very helpful contextual aspect. Thank you.
No problem. So with that context, everything that we have had to discuss is how we cross over the corridor, how we can still continue to farm the land that's behind the pylon line and make best use of that land and have as least impact on agricultural operations. So that has been the basis on which we have looked at everything. The key agricultural challenges, and obviously everything we're looking at for our client is on a tenanted basis, so it's purely the disruption to agricultural operations. That is what our clients' interests are here. And to be clear as well, we have got both ownerships, but the most of what we're going to be talking about is to do with number 18, it's Strong Gasol, because that's where the biggest impact is. So that is where most of our focus of today is going to be directed, because that's the biggest impact on our client. So those areas, particularly at lambing time, this is where sheep are moved to lamb, and it's because they can be easily worked in these areas. They're far more sheltered. They're not as remote, and so on and so forth. So that is the single biggest point in the agricultural calendar for where you're generating your next progeny, your stock, which will provide your income for that year. So that has been quite an important and crucial aspect to resolve. So as part of that, we've had to agree methodologies for where we can do alternative lambing, potentially putting in different paddock areas, and all sorts of things around about that, which has included upgrading roads to crossover point and so on and so forth. Now, all of these things we have made really good progress with Scottish Power on. So we've had quite a bit of dialogue on that, and we have pretty well got that resolved now. That's been really good progress, and off the back of Sarah's last meeting with Malcolm, we're just about there. The biggest contentious issue that we've still got is to do with bracking spraying.
Yeah.
And the client has been quite active in having aerial spraying done to improve the land and make it as productive as possible. And obviously pylons create quite a restriction in terms of where helicopters can come to and what they can spray, and therefore the corridor of land. And again, some of these areas, it's really important our client can improve them. So the reason there's been a delay with that is because Scottish Power weren't sure how they wanted to handle it. So initially, Scottish Power had said, well, we'll just deal with that. We will undertake the bracken clearing and the bracken control under the pylons and of our corridor of the servitude. So that was how the conversation started. Then with changes of agents, and when Malcolm came on a bit more, and I asked that again, I said, is that really realistic? Malcolm came back to me and said, well, maybe not, maybe we should talk about a proposal for your client to how we could do that. So we did that. Then it went back to Scottish Power again, and again, Scottish Power were a wee bit, well, maybe we still should, and actually I've not had that bottomed out completely, so we need to go back and ask again whether or not their maintenance team want to do. Off the back of Sarah's meeting, was it last week? I think it was Sarah. We've Scottish Power have come back and said, no, look, just we're not getting anywhere. We're not getting prompt answers on this. Please go back and provide us with a proposal of what it's going to take your client to do that. So that's what we are doing. So that really is the main issue. Sarah can run through more of the issues and give you more context if that is useful. But really, the main issue that's outstanding just now is that bracken, and I think we will get that resolved pretty blooming quickly now. We've gone round the houses with it quite a few times as to how they want to resolve it, and they seem to be reasonably settled now that they want a proposal from us. We've already given them previous things in the past, so we'll be working from that. That's essentially where we sit, sir.
Okay, and thank you. I'm going to stick with the kind of context.
To be honest, if you had any particular questions, we can answer them, but I think okay. That was
right. I'll maybe ask Maury to speak, and then ask Katrina if she has anything arising from that contextual discussion as to where discussions are, and then we can move on to the issue of kind of next steps and what that means for us. Maury.
No, I mean, really happy to echo what Ian and Sarah have said, that this has been the sort of residual issue. The others have been discussed, and there is broad agreement. So this is really the outstanding point. And there was a submission made to Malcolm Thompson, which he's now considering. I think he actually received it yesterday, and that's now being given consideration. And that deals with the issue of the bracken management. And obviously that'll take a few days. And I'm hopeful, as Ian is, that we will then be able to draw a line under matters and get agreements in place.
Yeah. No, that's very helpful. I mean, I'm very grateful for the kind of the contextualization of all of this, because that was one of my questions, Ian, when I was looking at the plans. But I was also probably more concerned about the issues around lambing, because obviously that's the sensitivity, because of the livestock and the acute importance of ensuring that enough protection is made for all sorts of obvious reasons, that the kind of lambing process is protected. Bracken is important, but it's obviously perhaps not as important as livestock. So that's quite encouraging from that point of view. But just on that question of the context, Katrina, did you have anything you wanted to ask the parties today arising from what they've said?
No, thank you for that update. Nothing else to add.
Yeah. Okay. No, that's helpful. So I suppose this sort of the next thing that obviously follows on from that. There's actually two things we would deal with together. What follows on from that? One of which is what we think appropriate next steps are going to be, and the second related thing, which is something I know that Sarah had mentioned originally, and would kicked about a wee bitty towards the end of last year, as to whether there's any question of me and Katrina having to do a site visit to look at the subject. Now, we had been on the Knocknalling site already for the site visit we did after the hearing in November. But obviously that was in relation to Lord Sinclair's interest, and your clients weren't there. So I'm not saying that's the same as. But it kind of seems to us, I think, that given the nature of the objections that are outstanding, there didn't seem to be to be any particular need to undertake a site visit. And actually, it's encouraging the lambing thing was issue appears to be resolved, because I was working on the basis that there's no point looking outside lambing season, and the last thing you want is two reporters walking about the field in lambing season. So I was assuming that really wasn't a very sensible way for us to go about our business. But again, starting maybe with Ian or Sarah, I wonder if we just sort of think of those, answer those two questions. What is now the most efficient and effective way for us as appointees to proceed? And would you agree that the issues are now sufficiently focused that there's probably no benefit for us, whatever happens, in being shown around the sites?
Yeah, so if I can start with the site meeting aspect of it, clients fully happy to have a site meeting if you want a site meeting, but given where we are, nobody is wanting to have additional cost and additional time going into this. The priority was animal welfare and making sure that had been resolved, and we've made such good progress with that now. Yes, there's always going to be things that are going to come up, but I think we're at the point where we've got enough of a template there that our clients got enough of a comfort that if something goes wrong, we've got a mechanism whereby there'll be compensation factors put in place, or we can get to other areas for conducting lambing and or grazing and stock once they've lambed. So I think in terms of you coming out on site and seeing it, you're not going to see anything. The only thing you're going to get is the context that I was talking about the in-by land. So you'll see that on site for yourself, and you'll see that there's basically a strip of land between the road and before it starts to climb up, and that's where the pylons are to go, hence the complications. So you see that, but other than that, you're not really going to gain anything from a site meeting. Personally, I don't think so. We're certainly not asking for a site meeting. And then in terms of next steps, as Murray correctly said there, we've put a proposal back to Malcolm. I would like to think that maybe a couple of weeks we've got this thing resolved, and certainly as far as Stronggastle is concerned, we will be able to return a voluntary way leave at that point in time, and then deed of servitude will be getting completed, because it's obviously progressing with the landlord there already, but we'll need the sign off from the agricultural tenant. So we'll be able to return a way leave there and then progress with the sign off from the agricultural tenant on Stronggastle. I'm quite comfortable that certainly the principle of the deal, and therefore signing a way leave within a month, I would have thought that should have all been done on Stronggastle. On Knocknalling, it's slightly different in that Mr. Sinclair is obviously the landlord for our client there, and our client will not want to do anything to jeopardise what Mr. Sinclair is doing.
Absolutely.
But in terms of the agricultural side of things, we will have covered a lot of those points. So we'll be discussing with the landlord what is appropriate for our client to do and so on, because we won't want to jeopardise that relationship, that landlord-tenant relationship. So they are slightly separate things, but our main concerns from our client's point of view, will have been addressed by what we do on Strong Gassel, and then it'll be a conversation with the Mr. Sinclair as to how we progress, so that our client is certainly not being, still seem to be objecting and potentially having costs if we have resolved most of the issues. That's where we stand.
So that's very helpful, and certainly for the Knocknalling and the Sinclair land, I completely understand that, and I think there are ways in which, if we do reach the stage where the issues outstanding are accommodated between parties acceptably, then even if his objection, or their objection rather, is maintained for the reason you say, because obviously he has a relationship, not just as tenant presumably, but also as neighbour, there, if that means that the objection is technically still maintained, but it's understood in that context, I think we can report in a way that can navigate that. We can work around that if indeed that's what comes to pass. So that again is very helpful from that point of view. But over to the applicants then, and just their views on where things are, in particular on timings and site visit indeed.
Yes, thank you, sir. I agree with Ian. I think about 4 weeks or a month would be an adequate time to resolve what is the last outstanding issue, and hopefully achieve a documented agreement which would allow, at least at Strong Gassel, the necessary leave application to be withdrawn. And then the deed of service should obviously would take its own course. On Knocknalling, I understand it is delicate just because of the tenancy and the outstanding landowner objection, but a resolution there might be to revisit matters within the same timescale, within a month. Yeah. And hopefully, if all of the agricultural objections are withdrawn, then it may be that one solution would be for Ian's clients simply to confirm that that's the case, but nonetheless that they're not in that position to grant the voluntary way leave, and just leave it at that. And it just allows, I suppose, it allows clarity. Even if the application has to proceed in as a necessary way leave, at least then there'll be clarity around the actual matters which ministers need to have regard to.
Yeah, I think that would work. I think that would make sense. But Katrina, any thoughts on that?
No, that sounds very sensible to me.
Yeah. So on that basis, and that's a useful bit of clarity, certainly in terms of the arrangements me and Katrina need to make, because obviously, if there's any prospect of any further process or procedure, and if we did have any formal procedure, it would be virtual rather than in person. But just knowing that we can then plan the taking forward of this with other matters, with reasonable confidence, in particular that we don't have to travel to the area again to have site visits. As it happens, Katrina and I live equally distant from the area. Katrina's to the south and me to the north, so we come from very different directions, but we've got the same length of drive to get there. But it is quite useful to know that's not looking like something that is going to be essential. I'm certainly very happy to look in terms of a month, not least because I'm actually away in the middle of February trying to get some winter sun. So I'm back on the 18th of February, so that would give, if we were then to look to have, I don't think we'd necessarily need a meeting, but look to having at least written confirmation of an update by, say, I think it'll be the 17th of February from memory, I think, is the Friday by the end of that week, an indication from parties on an agreed basis if you can do so, but separately if needs be, as to the current state of play beyond that. And then after that, we can look and then identify perhaps in more detail, if there are some outstanding issues that are resolved, just how we go about the resolution of that, whether a small amount of extra time is needed, or whether me and Katrina need to actually have a sort of focused hearing session on that. Then we'll do that. Obviously, we have to do something to get progression beyond that if parties can't agree. So we'll think about the best way forward for that. But I think what I suggest is that we look for parties to give us an update by And I think Friday is the 17th of February.
Yes, it is.
Is the date, and that can be an issue that we and Katrina can discuss when I return to the UK.
Mr. Reporter, could I just make one request, please? Just in terms of Sarah's working week and so on. Is there any chance we could make it just the close of business on the Monday following? So I think that's the
20th. Yeah, yes, of course.
The 20th. Yeah. Just purely because Sarah won't be in the end part of that week, so if we'd make progress, then we won't have had a chance to look at it. So if hopefully it'll be done before then, but if we could make it in the close of business Monday 20th, that would be helpful if possible, please.
Maureen's nodding to that as well, so we'll take that.
Yeah, that could be the long stop before. If it can't be done before, then
if you do reach resolution in these matters in advance of that, then the earlier you tell us, the better. It's a long stop rather than a target date at once, but that should give a reasonable period, especially since, obviously, as both of you have said, there've been progress in just very, very recent days for all of that. Okay, well that's fine, and that's a good way of identifying a roadmap forward. I don't know if there's anything else anybody wants to raise when we're all together here just now, while we've got the opportunity.
Nothing from the applicant's point of view.
Nothing from us either, thank you.
And Katrina?
No, nothing.
You're happy as well. Okay, that's fine. Well, I'll just draw this helpfully short meeting to an end, and thank you for your assistance and cooperation. Cheers, thank you.
Thanks.
Thank you.
Thank you.
Bye.
Bye just now.
Thank you. Bye.